Okay. So looking at some of the open questions, Mino, your yesterday's question with regard to gratuity, I have checked up. It is very clearly given that gratuity is payable only after completion of 5 years, or you can look at 4 years and 240 days. The exception of gratuity essentially is only with respect to a journalist and a fixed term employee. For a journalist, it's within 3 years, and for a fixed term employee, it can be given pro rata. But other than that, you don't have to give pro rata except if the employee essentially has died. Then in that case, or is disabled, then you give pro rata gratuity for those individuals. So if you look at section 53, that very clearly provides for the applicability. It's the same as the present law. There is no difference as far as that is concerned. Coming to the next question, we are paying an allowance called food allowance. Will this entail a PF deduction? Yes, Anthony, if you look at the definition of the wages, it doesn't matter what you essentially will be calling these various allowances. So long as you're giving everybody that particular allowance, it will essentially form a part of the wages and therefore will be part of inclusions and therefore will be part of the definition of wages. And therefore, that is the wages definition that will be applicable when you do your PF deduction. It's the same kind with any kind of incentives that you might be giving through the payroll. All of that, if it doesn't fall under the 7 categories of exclusions that are provided, it comes under the inclusion category, and therefore you will have to give PF deduction as far as that is concerned.
Acromic point.